Okay, I'll go ahead and call to order this hearing of July 25th, 2024 in the matter of case file Z0033-24, an application for a forest camp or an appeal of denial of a forest labor camp. My name is Joe Turner. I'm the county's hearings officer. I'll start with some brief announcements and a summary of the process that will follow so everyone understands how you can participate in the hearing. I start by saying I am not a county employee. I'm licensed as an attorney and I trained as a planner. I serve under contract to the Board of County Commissioners. I say that so you know you're getting a somewhat independent review of the application or the appeal before me today. My role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in Clackamas County. In making those decisions, I'm required to apply the existing laws. I'm not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Planning Commission and Board of Commissioners to do that, or if it's a state law matter with the legislature. But state law requires that this application and appeal be judged based on the laws in effect when this application was filed. As a hearings officer, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to this application. I have not had any pre-hearing contact with any of the parties regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. I did receive an email this morning from county staff noting, heads up was the title. In your opening statement of the appeal this morning, you should not use the term somewhat unbiased. The appellant is already accusing staff of having unfair influence on whatever decision you might make. I think that's not really ex parte. It's letting me know that this was an issue, but wanted to make sure that was in the record so everybody's aware. Ms. Fields, you had some further follow-up on that, on the assertions of bias by the staff?
I have received 4 emails from John with additional information that John requested that the hearings officer receive. They have been saved to the file as exhibits, exhibits 5, 6, 7, and 8, and they will be uploaded to Acela later today so that everyone can review and consider them, including the hearings officer.
Okay. I have not seen those yet. I will review them. Mr. Rodriguez, if during the hearing, when is your opportunity, if you want to, you can summarize the concerns you've raised in those letters. So I can, but I will review them in detail before I do anything on this case.
There were 20 attachments that were made. I'm not sure.
I'm sorry, I couldn't hear you.
There are 20 attachments that have been made to those.
Okay, I'll review everything. So the procedure will follow. I will start by asking staff to summarize their the decision in this case and respond to the appeal. Then the appellant, Mr. Rodriguez, I assume, will have the opportunity to respond, at that point, the appellant will have the opportunity to respond, present your case, and any evidence you want to present or witness testimony, other evidence. Then if anybody else wants to say anything about this application and appeal in support, in opposition, or with questions or concerns, they may do so. Once everyone's had an initial opportunity to testify, I'll give staff and the appellant alone the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. Generally, I will issue a written decision within about 2 weeks after the close of the public record. I'll send my decision to the county. The county will send it to parties of record. So anybody who testifies orally or in writing before the close of the record will be sure and receive a copy of my decision when it's issued. Anyone?
When does the record close?
It hasn't. After this hearing, I'll follow up on that in a minute. I'm not done with my intro. So, right. Sorry, lost my place. Anyone with an interest in this application may offer relevant oral or written testimony, but testimony should be relevant to the applicable approval criteria, which are set out in the staff decision. Also, please don't repeat testimony offered by yourself or earlier witnesses. Repeating your testimony doesn't make your case any stronger. This isn't a popularity contest whether everybody loves it or everybody hates it is not an issue I get to consider. The only issue before me is whether the application does or does not comply with the applicable approval criteria. However, it's also important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that everyone can understand what that issue is. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. But whether or not the hearing is continued or the record is held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, but if anybody else wants me to hold the record open or continue the hearing for any other purpose, you must make that request before the close of the hearing today. Also, my decision must comply with state law that requires that I issue a final written decision in this case within 150 days after the application was filed. So there's some limit to how long I can hold the record open or continue the hearing. And Ms. Fields, I will ask when your opportunity to testify. Let me know what the 150-day clock when that expires. When you testify, please begin by stating your name and full mailing address. Please spell your last name so I get it right, although most people's names appear on my screen. Some are initials. And so I just want to make sure I get everybody's name right. If you represent someone else, please so. And that concludes my introduction. Then staff will summarize the the technical aspects of this Zoom meeting, if you will. Ms. Fields?
This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad have a raise hand button on the Zoom bar that is either at the top or the bottom of the device, depending on which device you're using. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you provide your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional testimony, email the written testimony to myself, Joy Fields, at jfields@clackamas.us, or mail it to Clackamas County Planning and Zoning Division, 150 Beaver Creek Road, Oregon City, Oregon, 97045. The staff contact is also available on the last slide of the PowerPoint presentation. And it's available on the web page where you found the Zoom link for today's meeting. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address. By emailing the staff contact for the application or by entering your email or standard mailing address in the Zoom chat function during the hearing. I see that John has a question.
Yeah, you said something about the last slide of a PowerPoint presentation. I don't understand.
Yes, when I go over the staff decision that you appealed, it will be using a PowerPoint presentation that I will be sharing with everyone in just a moment. And it will be an exhibit that is also uploaded on Acela so people can refer back to it when this hearing is over.
Okay, thank you. I'm sorry, I have lots of questions that
Not a problem.
I've never done this before. So
Was that it for your intro? Okay.
It was.
Give us your staff report.
Okay. So we are here today for file Z0033-24. That was for a temporary forest labor camp. The hearings officer requested that I let people know when the 150-day planning review clock ends. And my record indicates that review period ends on August 30th, 2024. That is 150 days after the application was deemed complete. So today we're going to be talking about the applicant's request for approval for a temporary forest labor camp to remove debris and slash from previous timber operation, harvest forest products such as mushrooms, and to replant. The application was denied due to 40604 and 130707A. The property is zone timber. The subject lot is a lot of record that is a combination of two tax lots. And previous staff research done prior to the submittal of this application indicates that both of these tax lots are combined as one legal lot of record. The site is currently in forest use with RVs on site. And the applicant provided evidence, including a letter from a state forester that indicates that the last commercial timber harvest took place prior to 1995. In ZDO 40604, a temporary forest labor camp, it is identified as a land use application that it could authorize a temporary forest labor camp for a period not to exceed 1 year. The criteria used to review this application included definitions in 40603 with referral back to the Oregon Administrative Rules and Oregon Revised Statutes. In 40603, a forest operation is defined as any commercial activity relating to the growing or harvesting or any tree species as defined in ORS 527.620. ORS 527.6206 identifies forest practice as any operation conducted on or pertaining to forest land, including but not limited to reforestation of forest land, road construction and maintenance, harvesting of tree species, application of chemicals, disposal of slash, and removal of woody biomass. The email that the applicant provided from Michael, the state forester, included the excerpt that indicated that they don't keep records back to 1990, to the early 1990s, but that it appeared that there were challenges in the reforestation process for this property based on aerial images. However, the conifers did not come back and were filled or were replaced by red alder, which is also a commercial tree species. And therefore, the property meets the stocking to be classified as forest land. Michael indicated that they did not have any notification of commercial harvest activity or forest management activities on the property on record. In the application, the applicant indicated that volunteers would be clearing slash and remnants of past disturbances, would be selectively harvesting tree species to preserve mature trees while fostering biodiversity, and engage in invasive species management, as well as education and outreach, and conducting scientific research to deepen the understanding of forest dynamics. I wanted to make note that the research for forest management and experimentation is a different land use type. It is a conditional use in the timber zoning district. And so that is not being considered as part of the forest operation. And I wanted to make note that staff did not find that a forest operation was taking place because there is no indication of commercial activity. And there is no indication of how long this commercial activity or forest activity would be taking place and how many people or who would be doing the forest practices for a particular forest operation. Additionally, 130707 states that applications have to be initiated by the subject property owner, the contract purchaser of the subject property, or an authorized representative. This is important because land use applications go with the land. So an approval of a land use application can be transferred to a new owner, and therefore having the owner's signature on the application and having the property owner initiate the application is paramount to ensuring that the property owner knows what land use approval is being considered for their property. Our records indicate that the deed for the property was signed in 2001 by Julia S. Rodriguez, who granted Julia S. Rodriguez as trustee of the property or as trustee of the property trust, the property. What that means is Julia S. Rodriguez is the trustee, and the property trust is the owner. In the application, there was no indication that Julia S. Rodriguez signed the application. And so in the incomplete notice, staff requested information on how John Rodriguez was authorized to initiate or submit the land use application. And as part of the response to the incomplete notice, the applicant provided this certification of limited agent of trust. The signature on this does not match the signature on the deed, and there is no contact information for Julia S. Rodriguez or the trustee of the property, or the trustee of the property trust. So there was no way for staff to verify by communicating with the property owner that the property owner gave John Rodriguez permission to apply for a land use application for their property. Therefore, staff denied Z0033-24 as seen in Exhibit 1, because staff did not find that the application was consistent with all applicable criteria in the zoning development ordinance.
Okay, I had a question on page 5. Let me find it. Under number 1, property history and project overview, second paragraph. You note there's no record with the State Forestry Department of commercial harvest activity, commercial harvest of special forest products or forest management activities for the subject property. Would permits or approvals, something from the state, be required for those activities?
The email from Michael indicated that the special forest products did require permits.
Even on
And so
private property?
It was staff's understanding after reviewing that email and the statute that was referenced in that email that the state forester would have some record.
Okay. And special forest products would be mushrooms and et cetera, I assume. And can the county approve consecutive 1-year permits for this type of a use?
If there is evidence that a particular forest operation has a term that exceeds 1 year, maybe.
Okay. There's nothing
However,
preventing that.
The code clearly says not to exceed 1 year.
Mm-hmm.
And our other sections of 1307, never mind. The sections that I was going to mention of 1307 apply to when there's a denial. And so if it was approved and resubmitted, section 1307 would not prohibit that, to my knowledge. I would have to read it to make sure.
Okay. Sorry, I just got to switch pens real quick. Mine just died. Okay, is that it from county staff at this point?
Yes.
Thank you. Mr. Rodriguez, it's your
Yes.
opportunity to testify.
Unfortunately,
Mr. Rodriguez, can you give us your name and address?
oh yes,
Your address is in there, but
John Rodriguez, JOHNRODRIGUES.
Thank you, sir.
214, Joseph City, Arizona, 86032. Is that good enough?
yeah, thank you, sir. Go ahead.
So, I was led to believe by the application that filed for this appeal, this would be handled in a de novo fashion, meaning that we wouldn't, it doesn't look like we're going all the way back to the beginning. We're going back to where the where I applied for this permit that I didn't really want and don't think I needed. I have email from the staff, Joy Fields in particular, that is already included in all the supplemental things that I've given you that say things like, you've been asking us too many questions and we just need you to fill out one of these forms. You can either file for a campground, which costs a lot of money, or you can get a temporary. I was told that one of those two things I had to do. And so I did the one because, not because I think I had to, but because I was told by the county staff that if I didn't, I would be fined and then I'd be in violation. There was a violation that started all this nonsense. So when we go back to the very beginning, what we need to look at is a court case, which is why it's Exhibit A for my stuff that I sent to you. Brentmar versus Jackson County. Are you familiar with that? Okay. In Brentmar versus Jackson County, Supreme Court basically looked at all the things that are allowed on resource type lands. And then later, administrative rules, OAR 660, was written more or less from that and a few other places, but more or less from that section of law, because the law authorizes the administrative rules. The administrative rules are quite clear. There are things that shall be allowed, and everything that I have been doing should have been under the shall be allowed group, not any of this nonsense where I have to ask permission. Actually, it's specifically barred in ORS 930. One of the supplemental pieces of information that I've given you is a document that shows that the complaining neighbor that started all this is on EFU land. And EFU, they're specifically barred if they don't have a civil action, then the county is specifically barred from proceeding and making nuisance and trespass, which is where this all came from. So then I did fill out the application. I'm prepared to proceed in either way, but I don't think I never wanted a temporary forest labor camp. What I wanted to do was to engage in forest operation and forest practices. And I needed temporary structures that go auxiliary to that. If you look in the county code itself, in the very beginning of their table, there are 4 or 5 allowed uses, one of which has to do with marijuana, and I have nothing to do with that one. I don't care. Everything else says, here's how forest operations work, and here's the stuff that you can do on this kind of land. And in 406-1, the table. If you're familiar with that table, the very first thing says forest practices of forest operations. The state forester admitted he doesn't have any records. And further than that, I've gone to the historic records division of the state of Oregon, and they tell me that they don't keep anything over 5 years. I have a current operation that is, well, current. It was current when I filed this stuff. It was in March of this year, where we were burning slash. I had to register that with the state forester. Last time I did that was in 2009, when I registered with the state forester again. I harvested 3 acres. I got the tax forms, and they're all there in your records that you have been sent, that I've sent to you. Everything's there for you to look at. I don't know if you can see it all. But I'd be more than happy to go through the Brentmar case, because I think it's completely salient here, because the county's code must comply with state law. And
I'm very familiar with Brentmar, so
okay, good.
I know where your argument is.
Wonderful, because there are things I'm supposed to be allowed to do, and I've asked specifically in emails to the county planning department, hey, I want to do these things. You keep talking about this other stuff. I want to have temporary on-site structures to facilitate the forest practices that we're engaging in. And I was told, you need to fill out this form. And it just kept going back and forth. I got an email that said, you've asked us 18 questions. I'm sorry if I've asked 18 questions. I've only gotten 4 answers. And then the communication broke down. And what happened was, communication that I got was a letter that said, you will be fine. We will proceed on the violation that we've given you. And so I filed this appeal. I contacted Mark Scholl, who's the county commissioner, and said, I don't understand. And he said, proceed through this process as best you can and make sure that I stay apprised. And so for everything that I've sent you, he's already gotten copies of everything. He has been quite wonderful and quite transparent. And as you know, everything that goes to the county is already part of a county record. So there's no game that you can play that, well, you can't get access to the stuff. It's all there. And so with regard to the ex parte concerns that I had, I can't email directly to you, but the county planning department, and admitted that they did it this morning in discussion of this case. I don't know how you have to set it up. I understand that you didn't set it up, but if I were to set it up, I would say, here's an email place. Everybody can have access to that email, and everything's going in the record. And that way it's not, but at this point, if I want to send you something, I have to send it through Joy Fields. And then Joy Fields said, oh, by the way, here's a private communication between you and I. And I mean, I guess it's on the public record, but I wasn't CC'd on it.
I understand.
Yeah, so that's
staff sends me scheduling emails. Ms. Reinhardt usually sends me the scheduling emails. Here, I got a hearing this date. Here's the notice, etc. So that's generally the only thing I get, other than that one email that I mentioned this morning.
And it's nice that in the documents, they said that they did address the items that I answered, because I answered every one of those items. I had to take the trustee directly to a notary. She appeared in front of the notary and said, I'm the trustee of this property. That is my signature on the trust. It's not my signature for the county when I filed with the thing, but it's my signature on the trust. And it says that in the documents there. You would probably have it as answer to item A, letter 1, certification of limited agent of trust document. And so that's there. It should be included in the things that you have.
Okay, Mr. Rodriguez, just to make sure you understand what I have.
Right.
I understand there's an enforcement proceeding that's separate from this. I don't
Okay.
have that record. I have the record, which is exhibits 1 through 5. Included exhibit 2 is your application. Yeah, all of 2A through F is your application materials that you've submitted.
Right.
So that's what I have before me. I'm assuming that what you're referring to is in that application materials, but I
Okay.
just.
All right, then, so is the scope of this hearing only to address the application which was denied, or is it to?
Correct.
Okay,
I have no authority over the separate enforcement proceeding.
fine. In the only thing that I have here, which is I don't have a copy of that PowerPoint. And maybe that's something I can get, and I understand that this is
Absolutely.
more open-ended than I thought. The decision won't be rendered necessarily today, and we could ask for more time where we could, or even another period where we could get back together and do it again. And I may do that because, as I said, I've never done this before. I didn't have a PowerPoint. I certainly could have made one, but I didn't have a PowerPoint to present my argument in a clear and concise manner, and I didn't understand that wouldn't be able to ask questions of the other side, that I have to basically present my thing, and then you can ask questions of what's presented. Is that correct?
If you have questions for staff, you can ask them now. I won't go back and forth, but you can, make your question. When it's their opportunity to testify, they'll respond. You'll get a chance to respond to their response.
Okay, my questions come down. So in the notice of a decision on type 2 land permit, 406.04, it says uses permitted in the timber district are listed in this table. And then it talks about that type 2 temporary forest labor camp for a period not to exceed 1 year. That's the in the county code. If you find temporary forest labor camps are allowed outright under subsection L of 660-006, 00.25. Anyway, that's exactly where those are allowed, and they're allowed outright. Now that list, unfortunately, is not as clear as what goes on in Brentmar, because in the 215-283 list, there's section 1, which is this stuff is allowed outright. Nobody can bother. It's a right given to the guy who owns that property. Then there's section 2, which is these are things that are regulable by the. Unfortunately, in the OAR, it's not delineated like this list is stuff that's allowed. However, temporary forest labor camps are analogous to the type of labor camp that would be necessary for farmers to have. And those are not regulable by the county, and they can't say that you can't have farm labor because that, and so even if we have to go back to 215.203, which says all farm uses that are delineated in that, which then rolls us right over to 215.283 subsection 1, which allows me to have everything necessary to deal with the harvesting and propagation of forest products. Whatever it is that I deem to be necessary, and there's no limit on the amount of time. Actually, the only limit that's ever listed in 660 talks about temporary means not for the entire life of the forest. Yeah, I guess my concern is that, but with regard to the application that she's got here, she says that I didn't have it doesn't look like I have any operations. I have evidence that I submitted to you as well. that is a scan of forest operations that we had 2009, tax receipts and all that. So that's not true. And the fact that the forester wasn't able to find it doesn't make it a fact. And that's an important distinction that we need to know here, that I'm fine with basically making it so that his testimony be struck from the record because he was in error. I don't believe he did it intentionally, but I know for a fact that the state of Oregon doesn't keep anything older than 5 years. And I also know that at the state tax department, they rechanged their computer in 2015. So everything over 2015 is lost. They don't have anything. And I got that on an email directly from them. Matter of fact, you will have a copy of that in the stuff that I sent over. So with that regard, I don't understand. So there's two things. Number one, they didn't know who it was, but they took the money from the appeal from me. And then they said, we don't know who you were. And I sent a letter of certification of a limited agent of trust. And I am the certified agent for this. I'm actually one of two, but you get to deal with me today. So I don't understand how you can claim that you can't talk to somebody, but at the same time, talk to somebody. So that's the question that I would have directly for the staff is that, what is it that you would need? If a notarized document that says the trustee appeared in front of me and
but it doesn't say who that trustee is. It's just signed with an X saying trustee of the property. There's no name, address. There's no evidence that, I mean, I'm not accusing you of anything, but somebody could create that and we don't know who did it, who signed that, who that person is.
What you're claiming is that the notary did not verify the identity of the person like she claimed.
But it doesn't even say who that person is. It doesn't say who appeared in, it just says trustee of the property.
The privacy of the trustee is protected, correct? Very much so. The trustee
but it's listed on the deed as who the trustee is. So there's no privacy issue. I don't see any privacy issue.
Yeah, I understand, but you also don't understand. You also didn't see the fact that other properties have been harassed, and it is not wanted that would happen to the other properties that the trustee would have. And so they're making sure that their name is not put out there. Absolutely. They own more than one property, and they do not wish this stuff to start spreading because, well, let's go look into that. And so there's no reason that you need to know the name of the trustee.
It's part of the record. Well, they do know it. So I don't see how that's an issue.
No. Their claim is that the trustee, the signature does not match the trust document.
And there's no indication that the person who signed that is the trustee of this property. It doesn't list Ms. Rodriguez's name. I think it's Julia Rodriguez. So anybody could have appeared and signed that thing.
Anybody who had the,
it has to be this person. It has to say this person appeared in front of me, not this trustee with no name.
No, I do not believe that's correct. The person,
okay.
The
that's staff's concern, but so I'll consider your argument. I'm not ruling on that issue, but I'm just trying to reiterate staff's argument.
I understand. Okay, so the trustee appeared in front of the notary, identified themselves, and the notary actually put that in their notary certification. That's in the documents that have been sent. And they have that. So I don't understand why that wasn't good enough. It was fine to take the money. It was fine to set up this meeting.
Okay.
Not fine to give us the thing. It was fine to take the $1,000 for the application. Also fine. And I don't understand. So you're either engaged in one of two things. You're conducting business and discussing matters you have no right to discuss with me, or you're not. And so it's nonsense to try to pretend that you can't discuss this with me, and then that's the reason why we can't do this. That's nonsense. It can be documented that it's nonsense, and it's not necessary for the trustee to disclose who they are. trustee does need to be able to authorize an agent. And they did. I don't understand why that's not being accepted. And actually, it was fine to accept the money. It wasn't fine to issue the permit. That's nonsense. You either be consistent or not consistent. You can give back all the money and we can go our separate ways.
I understand.
Anyway, so that's the first problem. The second problem was 406.04, and I'm confused as to exactly, in the letter that I have, it says the criterion was not met. But it isn't clear what the criterion is. As near as I can tell, they're mad because I have to have a forest operation, but forest operations are specific commercial things. I have had them, but I don't have them all the time. No forest property does. And so there's lots of times when the trees are just doing their job. They're just growing and nobody has to go bother them. And you don't have commercial plans with them. Most of the properties in the state of Oregon. But what we do at that time is we're engaged in what's called forest practices. And the act is quite specific that it says you can engage in forest operations or forest practices. It doesn't say and. And that's an important distinction. And they're trying to make it say, no, you gotta have operations. I don't have operate. I do have operations, but I don't need to. And that's a very important distinction. And then with that, if that's the two sections of the thing, I can answer every point in the thing where the criterion wasn't met to the best of my ability. But unfortunately, most of the two of them come back to the idea that they're not happy that they don't know who the trustee is. So how would
that's a separate issue? So let's focus on 406.04 right now.
okay, fine, and so 406.4, I have in the documents that have been sent to you, there are evidences of not just one but several operations that have occurred. Both of those they're all covered in there. The times that we've had to talk to the state forester, we've done so, and it's worked out fine. The fact that they don't have records, I can't answer to why that would be. The fact that the county should know that they can't contact the historic records and get those records. Obviously, the county doesn't keep them, and so they just rely on more or less hearsay. And I have evidence to show that it was incorrect, and that's fine. So I guess that puts that. But have I addressed? Is that the criterion? And I guess this is a question for Joy Fields. Is that the criterion that you were upset that I did not meet? Is that I didn't have a forest operation? That would be the question for 406. And with regard to the other one, with regard to you, Ms. Turner, what do I need to do? How would the trustee appear before a magistrate? How does the trustee preserve her position of anonymity and the other properties that once you got your name on it, they're not in this trust. They're in separate trusts. They're segmented on purpose.
Okay.
Lots of reasons. But how does she maintain her anonymity and still make it? What would it be that you would need to see that would say, no, that guy, John Rodriguez, is the guy, and he was an authorized agent, and she meant to say that he was an authorized agent, and how do I get that done without violating her anonymity? And that would be a question that I have for you, because that's the crux of this. Is they say we don't know who it is, and that's what they claimed in their in the letter that I have. That's what they claim. We don't.
I understand, and let me respond to your question then. If her anonymities, she didn't have anonymity. She signed the deed. Her name is on the record. So on this property, the other properties, other trusts she may have are not relevant. So there's no reason to make any reference to those, for the county to investigate those. That it wouldn't affect her anonymity. You know what I'm trying to say? Anonymity. Sorry, brain block there. It wouldn't affect her and that with other trusts. It's only this trust and this property, and they want to know that the owner, the record owner, authorized you to act as their agent.
Who is the record owner?
The trustee. The trust is the record owner. The trustee is the Julia S. Rodriguez.
Who's the
So they
trustee
have to know that Julia S. Rodriguez signed that.
No,
that-
Julius S. Rodriguez was the creator and the original trustee. The trouble
who's
that
the new
we're
trustee?
having is that,
Somebody has to act on behalf of the trust.
right,
And that's
and
the
they
trustee.
did,
If there's a new trustee, somebody else has to identify themselves as that trustee.
and they did. But if that person acted on behalf of the trust, and the trust did exactly what it needed to do. It said, we're assigning this person as our agent. They identified themselves and they did that. The problem that we're having is you're confused. Let's put it that way. The trustee is not the grantor. How about that? Does that help?
Yeah, I agree. Yeah, somebody had to own it and transfer it, but somebody has to act on behalf of the trust.
The trustee, okay, how about this? Let's see if we can make this be clear for you. There is a succession to trustees.
Uh-huh.
The succession has occurred. And so Julia Duncan isn't going to be able to appear, but that does not mean that the trustee did not appear.
Okay, who's Julia Duncan? Because there's Julia Rodriguez, according to the documents that I have.
She got remarried after this.
Okay. Okay. Just, I want to make sure I know who we're talking about here.
That can be documented, yeah. And Julia Rodriguez Duncan no longer exists. But that doesn't mean that the trust doesn't exist, and it also doesn't mean that the new trustee wants everything to be known about what she has.
Okay, I'm sorry, but Julia Rodriguez no longer exists as the trustee. Is that what you mean? She's no longer the trustee?
No, she's no longer alive.
Oh, I'm sorry.
Yeah, right? It not like it happened yesterday.
Yeah, okay.
Yeah.
I follow you now.
The trust and the trustee did exactly what they did, but they also maintained their anonymity. They do not wish to have their.
Okay. Now I follow you.
Good, thank you. Very good. But I am limited agent of trust, so I don't understand why. I mean, no one disputed that. Well, I guess they did dispute. We don't know who did this. So what would it take? How do we do this? Go to a judge? Would a judge, because they're self-notarizing, would an appearance ahead of a judge with the trustee say, I want to maintain my anonymity, but I want to authorize this date that isn't anonymous to deal with this junk? How do I get this done? That's the
I
question.
assume that would do it, but
Would that do it?
I assume so, yeah.
Okay, good.
If you can do that.
Okay, that's that. Then if that would work, then I request that this be held open. So after the fact, so that I can provide that information, because that's, as near as I can tell, without the answer to my original question, I'm on 4064. If it's just about forest operations, I've already addressed that and I can handle
Right.
that. No problem.
Okay, but as far as the record open, continuance, whatever.
I have one more question for you as well. But okay.
Sure, I have, but I don't want to leave this, your request for, I want to respond to your request for a continuance or record open. Running up against 150-day clock. You can extend that. So if you're willing to extend that clock, I'm willing to grant a continuance or a record open, whichever you'd prefer. Prefer.
Didn't they say the 31st of August?
Pardon?
Didn't they say the 31st of August?
Yeah, yeah, 30th,
30th.
August 30th.
August 30th. I have no problem.
So how long do you think you're going to need to get that?
It wouldn't take long. And now I've got more questions, but it wouldn't take
Okay.
long.
My other concern, I'm leaving on vacation for 3.5 weeks, the 20th of August. So I wouldn't be able to get my decision out until later. So I would have to hold it open for longer or,
Can we?
so you're aware.
Can we
So
go
these
August, September? Let's go October 15th. That would be plenty of time.
okay. That would give you, because the courts can be not as rapid as one would expect. So I just want to make sure you also have time. So I'm good with October 15th.
To that point, I would be happy to, if I get there and it's going to be longer, and then I guess I'd have to send email to Joy, and then Joy would send it to you, but then I would get it to you that I need more time.
Yeah.
Okay.
Yeah, that would be fine.
That'd be
There's also another drop dead date that it can't go more than a year total, roughly.
Okay. I don't,
Anyway, so long as you're aware of that, so there's some limitations.
The county where the trustee normally is and where they will go to is exceedingly small. And so.
Yeah, that's great. So if you can get it in, great, sooner, great. I just want to make sure we both have time and, do you
and
want, one more question on that issue. Do you want me to hold the record open so you can just submit it in writing? I think regarding that issue, I think that's going to be adequate.
I think that'd be fine. Yeah, that'd be fine.
Okay, good. So I'm willing to hold the record open for that purpose.
And then I get a week. My understanding, I get a week after everybody else is done, and I get the week and nobody else.
Right. So what I would do is hold it open for a period. We'll go with October 15th for now. I think we may need to adjust that for you to submit that and anything else you want to submit. Anybody and if anybody wants to submit anything else, anybody else, if there's opponents, if the county wants to submit something new, they could.
Okay.
Then I'd give everybody a chance to respond, probably a week or two, to respond to whatever you submit and anybody else submits. And then after that, you get the third period to submit your final argument without any, argument without any new evidence. So that's what I would do. We'd come up with specific dates for all that.
Question that has not to do with either of those two concerns, because those look like the two concerns that they were focused on here. I can answer, but and it does make sense, because if you look at the thing, they're kind of like in two groups. They broke it up into 5 different things on my letter, my notice of denial. But when you go through it, it's really the same evidence you use twice. So that's fine. I have no problem with that. My other question that I have has to do with the appeal process. The appeal form on the county website that I filled out to get this started so that we could have this meeting says that after the hearings officer issues a judgment, I have the right to appeal again to the Board of Commissioners. Is that not true? Because from what I heard earlier today,
I don't think so.
Doesn't look like if we were to go to the
Field, can you answer that? I see you shaking your head. It goes to Luba, doesn't it?
John has asked several questions, and I anticipate answering those.
Okay.
But you are correct. Your decision can be appealed to Luba.
Okay, but not the Board of County Commissioners.
Correct.
Okay. So if that says that on the appeal form, that's something the county needs to change. But it is my decision is final for purposes of the county. It can go to the Land Use Board of Appeals.
Okay.
So go ahead, Mr. Rodriguez.
No problem. Yeah. So in summary, I guess if all we can handle is the thing, then yeah, I'm annoyed because this is not what I ever wanted. You know, having a temporary permit of a type 2 application or a type 1 application, how they grade these is wildly different county to county, which is one of the things talked about in Brentmar, that they didn't want that. They wanted it to be uniform statewide. For a good example, in the Brentmar case, they talk about farm stands. Farm stands are allowed by right under subsection, I think it's O in 213 or 215-283. Subsection O is farm stand, markets, farm markets. So, okay. You can go to the Clackamas County website right now. If you called them and you did it anonymously, they'd say, and you said, hey, if I have a farm stand, do I have to pay for a permit? Yep. Fill it out. It's 8 pages long. And give us $1,000. It doesn't sound like a right to me. That sounds like you've converted a right into a privilege. And it's all over the place in this kind of nonsense that the counties are up to. I brought this to the attention of Jackson County because I used their planning department as kind of a soundboard, and they have taken down their zoning ordinances at this point. They're no longer up on their website, and the only copies you find are being marked up like they're knowing that there's a guy who's irritated enough that rights have been violated. And I understand that 3930 says that 38 says I can get
3938 of what is that? OAR
or ORS 3938, which is says that for when this stuff happens and they hassle you, you can get your attorney's fees after you.
Oh, okay.
And so that's and that makes it a lot easier to find a good attorney who can help you, because this is not a simple process. But it's not that I'm out in left field on this. I
Yeah,
can
I just wanted to make sure which state law, county code, what we're referring to. So appreciate the heads up.
It's ORS 30.930, and then
Yeah.
that's it specifically 35 says counties can't do this. They can't
I understand.
about this stuff, and yet they are.
I understand.
Yeah,
Yeah.
yeah, that's exactly where I'm at. Thank you very much. I guess at this point, I'm happy, and then I guess I have to prepare some more documents, and I'll be happy to get that done for you. Thank you.
Great. Thank you, sir. Is there anybody else? Gotta move my mouse so I get rid of this thing that's in front of me. Who'd like to testify about this appeal? I've got a couple people online. If so, please raise your hand. Ms. Fields, I see your hand. We'll get to you next. I'm not seeing any raised hands go up. So anything further? Response from county staff, Ms. Fields.
Yes, I wanted to note a couple of things that the applicant specifically asked staff to clarify. One is housing is not an allowed use in the timber zone unless special circumstances are met. And RVs are not allowed to be used as dwellings, as permanent dwellings. So those two things come into play on why a land use application was necessary to be able to have RVs on the timber zoned property used for housing. The forest operation in staff's mind has to be current because, as the applicant just stated, trees grow. And there's a lot of times where no one has to go bother them. If no one has to bother them, then there's no reason why there needs to be a temporary forest labor camp during that period of time where the trees are just growing. Staff understand that thinning, removing slash, maintaining roads, all of that can be done without housing, or if there's an intensive period of time where that needs to be done in preparation for a commercial forest operation, we need to know the term, the time period or the term that is going to be occurring. And then a forest labor camp could be reviewed and approved to support the forest operation for that limited time period where intensive action to support the commercial forestry activity is necessary. As noted by the hearings officer, the certificate of limited agent of trust did not include any note from the notary that the trustee appeared before the notary. And so there is no evidence that the trustee was the one who put the X on the form, based on the form that the applicant provided. Those are my responses to the questions that I heard from the applicant.
Do you want to, is anything further you want to add at this point?
This is me.
No, Ms. Fields. Okay, go ahead, Mr. Rodriguez. Anything you want to add at this point?
Yeah, the certified letter that she received did include multiple notarized documents, one of which was the certificate of limited agent of trust.
Mm-hmm. Yeah, I've seen it.
Had it at the bottom, and then it had that the notary's certification that person had appeared and that they had personally in front of them and had identified themselves, and that they were authorizing John Rodriguez and Stephen Jones to be agents.
I understand.
That actually is, and we have the certified mail receipts from that if we need them. So yeah,
Okay.
if those are something that you would like me to make sure that you have copies of, I'll be happy to get copies to you as well.
If you want to submit it, I'll consider it, but I can't tell you what to submit.
But importantly, actually immaterially,
let me follow up. I'm not sure how relevant the certified mailing is going to be. It's the document itself that I'm concerned with.
And this may be a mute point because we're going to go to the judge.
Yeah. Yeah, I agree.
Solve that problem. So
Right.
that makes good. And then I think something else here. I didn't hear an answer. Oh, so they think that they need to have forest operations and not having a forest operation, but having forest practices. Okay, and I think I understand what their concern is there. I'm just not sure how that's a criterion specified in the thing that I have to have forest operation. That the
Right.
forest operation has to be true. And I don't see where that's a criterion. I mean, that it's not met is also not true because, well, as of March of this year, we were burning slash plows. Well, we had a right to burn them. It turns out that the people that have been working on the property removed the slash in a different way and much smaller fires that allowed the ashes to be distributed in a much better way. When you burn them in one spot, you get them in one spot, and the plants love it. The plants, you can talk to any state forester, he'll tell you, plants love it when you burn the slash because it puts everything that a tree was mineral wise back into the ground.
Right.
But right,
and that is a forest practice.
Yeah,
Yeah.
it put right where it was, unfortunately. When we do it this way, we have much smaller fires. We have much less chance of fire
Right.
risk. But
Right.
you've seen the transformation in the undergrowth. That's
Okay, that's great. But what I want to know is what difference does it make if you burn a big slash pile? You have to get permission from a permit or approval from the state. If you burn dispersed, you don't.
Yes, if you're burning smaller than a certain size pile, the state forester.
Smaller than a wet size.
I'm not sure of the tonnage, but
Okay.
there's
a specific limit.
And then, so I purchased a permit to do that tonnage because he says it's really the smallest one we have, and it doesn't sound like you have that big of a pile. I said, I don't, but I got to have a permit in case we go. And then you can burn even when the county says it's not appropriate to burn because you have a state forester involved, and then the state forester says
Right.
that we're allowed and we know about it, and they make sure that everybody knows so that fire trucks don't roll around because that doesn't help. But
Right.
at the same time, the point is that by doing it in much smaller things, we're distributing that to much wider.
I understand. I think it's great environmentally, not relevant to what I'm considering. Can
But
you, during
we
the
did-
open record? Yeah,
we-
I'm sorry, Mr. Rodriguez. With this Zoom meeting, we don't hear each other when we start talking. I don't mean to interrupt, but
No.
I just during the open record, can you provide me a citation to whatever regulation you're referring to that says you have to have a permit for this size of a pile. You don't have have to have a permit for this pile smaller than that. Something to that. You know what I mean.
Yes, I'll be happy to do that.
That'd be great. Yeah. So I don't. If I have that in front of me, it makes my life easier.
Okay, no problem.
But I understand what your argument is here.
Okay. State forester, just a sec, I got to make a note here. Thank you.
Yeah, no problem. And I had another question for you as well.
Okay, go ahead.
You said you harvested 3 acres on the site. I didn't catch when you did that.
2009 it was done. It took me a bit to find it. Fortunately, my mother was still alive then, and so she didn't ever throw anything away. I mean, I don't mean that like she's a hoarder.
No, I don't totally understand. We don't need to go into that, but
She was.
okay.
but
So 2009 was when the last harvest was that you're aware of.
2009, and then there's some tax receipts and stuff like that we had to pay.
Right.
When the commercial,
Okay.
they were alder that were hauled off, and they were right off of that place where the camp is right now, and it's from that we're heading forth into the rest of the property to make it so that, and yeah, it's unbelievable the change. It's so good, so happy. Anyway,
Okay. Anything else you want to add before I close the hearing and hold the record open?
no, I guess one more question. Can you open can there be another hearing? If there needs to be another hearing, would there be another hearing? You would just do that?
You could make that request in writing. Yeah.
Oh,
I think at this point I'll just hold the record open. But if
The record open, yeah, okay, good. I'll
Okay.
just hold it open. And I'm sorry if I'm the youngest of a big family of 6, and there was never, this Zoom meeting concept is horrible because we always talked over each other. It was always awful.
Yeah.
I'm sorry.
No problem. I just didn't want you to think I'm interrupting you. It's just I have a
appreciate
question and we can't hear each other when we're both talking because of the Zoom, and there's definitely a delay. And it's not just you; it's every hearing I do that I have a question. So appreciate that. So what I would like to do is hold it open until we'll use October 15th for now.
Okay,
If you can get it sooner, I would, um, since there's nobody else that's interested in this, it's you and the county. So I think I can limit it. So if you're able to get whatever you want submitted sooner and include in that a statement, this is my initial submittal.
okay,
That would stop the clock soon, or the open record sooner. Let us get this, proceed with this sooner. So then I would give the county and the public, if they want to, an opportunity to respond after that.
okay.
So, Ms. Fields, if I give you 2 weeks after the close of the initial period, would that be good enough? Okay, Ms. Fields,
Yeah, 2 weeks is plenty.
okay. And do you intend to submit anything during the initial open record period? Okay. So let me get my calendar here. I will hold it open. I have to talk and write at the same time, and I'm speaking louder because I know I'm away from my computer. I'll hold it open till at the maximum October 15th. It's a Tuesday at 5 o'clock. 4:30 actually. What time? 4. I do this in different jurisdictions. Everybody closes at a different time. So anything you want to submit, Mr. Rodriguez, has to be physically received by the county by 4 o'clock on the 15th of October. And I'm just writing my note, so I don't have to do this again. By the 15th of October at the latest.
Okay.
I would give the county 2 weeks till the 29th of October, and the public, if anybody pops up and wants to say something, to respond, just respond to what you submit.
Okay,
And then, just so nobody can raise any new issues, I'll give you another week until November 5th for a final argument without any new evidence.
got it.
And I will hold I will issue my decision. I will try and get it out by the 19th of November. Would you be willing to extend the 150-day clock till December 11th, just so we don't have any issues in case, who
Absolutely.
knows what happens?
Yes, absolutely. Or if you need longer, please ask.
Okay, so I will need you to submit something in writing today or by 5 o'clock tomorrow,
Okay,
saying I'm extending the open or the 150-day clock until December 11th. So that's clear. If I don't get that, I won't be able, I'll have to, we'll have to, we're stuck with the existing 150-day clock, if you will. I don't think it's going to be a problem. It never has been, except for one case recently in the past, so I want to make sure that happens.
okay, good.
So nothing against you. So 150 days till December 11th.
Okay, and do I send that to Joy?
Yes, please. Oops, 12, not 10. Okay. So that's what I'm going to do. As I noted, if you are able to get something sooner and say so, the clock, the initial period will end on that date when you submit it. The county will have 2 weeks from that date to respond, and the public. You'd have 2 weeks, or excuse me, 1 week after that 2-week period. I will ask county staff to send me an email when they get your submittal, if it's early, prior to October 15th. And I will try and issue a interim order saying, okay, clock, that period has ended. The new 2 weeks starts on this date.
Gotcha.
The 1 week starts and ends on this date, et cetera. So everybody's clear when those deadlines are. Because I'm going to try and write that order, I'm likely to say you submit your something on September 15th.
Okay,
I'm able to give the county a little, start the county's response date a few days later, depending on where the 15th is, just to allow for everybody to get notice and et cetera. Because it's not our usual, usually we have a specific date, everybody knows what it is, they're prepared for it. So that's what I'm gonna do, just so you're aware.
very good.
I'll include that in my note, but I would ask staff to be sure and flag that in an email saying, don't forget, this came in and you need to respond to me. So that's what we'll do. Thank you all. That concludes our hearing.
Thank
Have
you
a
very
good
much.